Hi, I'm going to go through consideration as part of contract law. So consideration is one of the key elements to a legally binding contract. You need a valid offer and acceptance, you need intention from both parties to create legal relations, and you need consideration. So there are a few different definitions of consideration. Quite basically, it's a thing that's given in exchange for another thing as part of the contractual agreement. So it could be money, it could be goods, it could be services, it could be a number of things. Curry versus Meiser give the sort of traditional definition. Essentially, it can be a sort of benefit obtained or a detriment that you give in exchange for something else. So what we have is this really simple principle. One person promises to give the other something else, vice versa, and that creates a binding contract. And that means that the two parties have something called privity, which I'll go into more detail in a separate video. But essentially what that means is that these people who are part of this contract can enforce the contract against each other if something goes wrong. And essentially there's two concepts to that. You are bound to the contract, so you must do what you promised, but you should also get your benefit from that contract in exchange. So if you don't get that benefit, you can also bring legal action. And that just basically sums up this idea that consideration must move from the promisee. So it must be given in exchange for something else. So there has to be an element of giving. If a person fails to give, that's where they don't tend to have privity and they tend to be considered a third party. And again, that's where issues of privity come in. We saw this in the case of Tweddle versus Atkinson, for example, where there was no consideration given by the son-in-law. The consideration had moved and had to move between the two fathers-in-law. You can also see similar situations in Dunlop versus Selfridge or Beswick versus Beswick in privity. So as part of that, what can form a thing given in exchange? Well, it really depends on the nature of the situation. So for example, in a scenario question, you need to identify what is the nature of the relationship between the parties and what's the situation that's going on. So first kind of big rule of consideration I'm going to talk about is what if you have a contract with a party already, you have an existing duty to perform something for them. So for example, you have to do work in exchange for wages. What if you are wanting extra consideration, or what if you were promised extra consideration from that same person on top of what was already agreed as part of the contract? Well, quite simply, if you want extra, you must give extra. So you must show that you've gone above and beyond or something different to what was originally agreed in the contract. And that's why cases such as Stilt versus Myrick and Collins versus Godfrey failed, because they weren't doing anything really additional or extra or different to what their original contract required them to do. Stilt versus Myrick, they were still required to work on the ship. It's just obviously the conditions were a little more difficult with two crew members down. In Collins versus Godfrey, the police officer was not doing anything on top of what he was already obliged to do as part of his contract. He had to go to court as a witness, and that's what he got paid his wages for. So he wasn't doing anything extra in this particular case. It's where they have, or where they've gone kind of above and beyond, or the nature of the work has changed. That's where you're more likely to be successful. It's seen in Hartley versus Ponsonby, where unlike Stilt versus Myrick, half the crew abandoned the ship, and that meant that the voyage had become significantly more difficult and almost a different job in itself. In Glasbrook Brothers versus Glamorgan County Council, the police weren't just being required to do something that they usually do, they were asked to live on site, and that was seen as something extra, so they were entitled to extra consideration. The leading case is William versus Roffey Brothers, and essentially what they have come down to is that consideration can be giving someone a benefit or avoiding a detriment. So in that case, for example, it was avoiding the detriment of finding a new carpenter and avoiding the detriment of having a penalty fee for late building work. The key, of course, with this is that there was no duress involved, so that it was the party's own decision to offer extra. It wasn't a sort of hostage situation where one of the parties turns around and says, I'm not going to do what I've already promised to do unless you pay me more. That is likely to be looked down on in the courts. Another rule that we talk about is what if you want to use the same consideration to satisfy multiple different contracts? And that is perfectly fine. So You can do one action or provide one thing, provide one service, and that will be consideration for different people. And that's really the difference between these two. So this is where you are asking more from the same person. This is where you are asking something from someone else. Key case was Shadwell versus Shadwell here. So in this case, the nephew had made 2 different promises with different people. Both of them involved him getting married. So him getting married satisfied the contract with his uncle to get extra payment, and it of course satisfied the contract with his now wife. That's perfectly fine. He only had to do once. He didn't have to get married twice, for example, to satisfy the 2 different contracts. So the next thing to think about is what. So what is going to be offered as consideration here? So how much? Well, the key here is that it just has to be sufficient. It doesn't necessarily have to be adequate for the parties involved. Because of freedom of contract and bargaining power, it's up to the parties to determine what is the right value for them. The courts don't get involved in determining whether that value is fair. That's what they do. They take a laissez-faire approach. They step back. It was up to the parties to bargain. They agreed on that. That should be enough. And as long as it has an economic value, so it's something that is tangible, so for example, it can be a right to sue, then that is okay. So we've seen cases like Thomas versus Thomas, where a pound rent was enough, or Nestle versus Chapel, where even sweetie wrappers were seen as adequate consideration or sufficient consideration. The value of those was irrelevant. If they wanted to accept a pound, if they wanted to accept sweet wrappers, that was up to them to decide. White versus Blewett failed, however, because the consideration to stop complaining about his father spending money, that wasn't something that had a tangible value. So that could not be consideration. Because they have freedom of contract, it's up to the parties to really determine what is right for them. So don't fall into the trap of thinking it has to be enough money. That's entirely up to you what you charge for your goods or services. When? Well, the law is very clear that past consideration is not good consideration. And what that means is you can't do something for someone and then suddenly magically demand payment from them for that. That's because it goes against freedom of contract again. The parties are free to choose which contracts they enter into and which ones they don't. So you can't just do something and then turn around and charge them afterwards. So it must be decided at the time that the agreement was made what consideration would be given and how much, or at the very least it had to be implied that some form of payment would be given. So it may not have been decided at the time of the agreement how much or the value, but it has to be clear that both parties were expecting to give something in exchange. That's really important because something that's just given on one side is a gift. And a gift is not legally enforceable. So if one person chooses to give you something and there's no obligation on the other side, that takes away the obligation on the gift giver. So it has to be that both of them had in mind that some form of payment would be paid, and then maybe later on that was just the agreement and the determination of how much it would be. So in Ree McArdle, she couldn't pay for building works, get the building works, the repair works done, and then ask others to chip in, because there was no agreement, there was no implication at the time that anyone else should contribute. Whereas in Lampley versus Braithwaite, the courts felt it was quite clear that because getting a royal pardon was such a difficult job, that both were on the understanding that when he agreed to get the pardon, there would be some form of payment given for that. And then later on, the £100 was the determining of how much that would be. And this kind of covers the idea of executed consideration and executory consideration. So executed consideration is consideration that's usually done at the time the agreement is made, not before, but at the time of. So for example, this is usually seen in unilateral contracts. So if I say, I will give you £50 if you find my dog, if you bring my dog to me, that is you executing the consideration, and I will probably execute my side very quickly by giving you the reward. Executory is simply a promise that's made at the time, but it will be done in future. So a good example of this would be your wages. So you agree to work for executory consideration. You agree that in the future they will pay you, but the key is it's very clear at the time that we agree that we know that there will be payment, and probably how much per hour it will be. It's just the agreement is I'll give it to you later, but we are very clear at the time of the agreement that that's what we're going to do. The final big rule that you need to understand about for consideration is what happens in the case of someone owing a debt to another person. Contract law, as demonstrated in Pinnell's case, is very clear on this. The only valid consideration for a debt is repayment in full of that debt, and that includes any interest. So under contract law, the only thing that can satisfy is paying it back, the total amount. And what that means is the person who is owed money is entitled to not accept anything less. So if you owe someone £100 and you say to them, sorry, I can't afford to pay you, will you accept 80? That is perfectly up to them to say, yes, that's fine, or no, it's not. And that's because of freedom of contract again. That person is owed the full amount. They are entitled to the full amount. However, in those situations where perhaps a person makes a promise, the law can expect them to honour their word. So if I say, I owe you £100, but I can only afford 80, is that okay? If that person agrees, remember they didn't have to because they had the right to ask for the full amount. If they agree, the law generally expects you to honour that in the law of equity and trusts. So this is traditional laws that are based on trust and fairness and honouring your word. There are two principles that you need to know about. They're slightly different, so be careful between the two. The main thing that you need to look for example, in an exam scenario, is are they offering part payment alone, or are they offering part payment and something else to make up the rest of the debt? So if they offer part payment and something else, so for example, I owe you £100, I can only afford to give you £80 cash, but can I also give you this chocolate bar? Will that do for the rest? Remember, we're entitled to say no because of contract law. But if you say yes, then the principle of accord and satisfaction applies. Accord means an agreement. Satisfaction means the debt is paid, it's satisfied. So what we mean here is that the rest of the debt is satisfied by whatever thing you offer. The remaining £20 of the debt, for example, is satisfied by the chocolate bar. Once you've accepted that other thing, then you can't go back and demand the rest of the money paid. That's because you've already received something in satisfaction of the debt. Promissory estoppel, two very simple words, promise, stop. If you make a promise that you'll only accept part payment of the debt, you're not expecting anything else. Sorry, I know I owe you £100, but I can only afford to give you 80. Is that going to be okay? Can we call it quits? Again, remember, you're entitled to say no, I want the full amount under contract law. But if you say yes, okay, I'll just have the £80 and I won't bother you for the rest, then the doctrine of promissory estoppel applies. You can't go back on your promise and demand the rest of the money if three criteria apply. The promise, that agreement, was clear. Both parties understood what was happening, and importantly, the debtor understands that they can't get the rest, they won't get the rest. They won't be asking for the rest. There has to be an element of trust and reliance. So we need to know that the person asking for promissory estoppel is really relying on that person not asking for the debt. So for example, is there signs that maybe they're struggling financially and wouldn't be able to pay off the rest, or that they need to use that money for other essentials? Sorry, I can't give you the full £100 because I need to get my grocery shopping in for my family. Finally, you must come to equity with clean hands. And what that means is if you're going to rely on principles of fairness and trust, you too must be fair and trustworthy. So there is a genuine reason you're asking for a promissory estoppel. You are not trying to cheat the person that you owe the money out to, things like that. So hopefully those rules of consideration make sense. What I would also suggest is that you have a look at the rules of privity in more depth, because that really explains the duties that we owe with consideration and the consequences if you don't provide consideration for a contract. Thank you.